On May 25th, 2020, Derek Chauvin caused the death of George Floyd by placing a knee on the back of his neck during an arrest. On May 29th, 2020, Derek Chauvin himself was arrested for the killing of George Floyd and charged with third-degree murder and second-degree manslaughter. Let's talk about those charges and the facts as we know them. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about Derek Chauvin, the Minneapolis police officer who killed George Floyd, and his now arrest and charges of third-degree murder and second-degree manslaughter. What are these charges? What are the facts that they have that led them to these charges? What facts have we not seen in the videos so far that are included in the criminal complaint? We've got all that right now, and we're going to burn straight through it. So stick with me. This is going to be kind of fast-paced for a lot of the information we're going to get. I'll keep it as short as possible. All right, here we go. So this is Derek Chauvin right below me here. And then here is we're going to do the charge elements first. And then we're going to look at the criminal complaint and see what the story that they have constructed about this is. And I'll walk you through all of it and what I think about it as well. Okay, murder in the third degree. Why not first degree murder? This is the family's calling for first degree murder. Why not charge first degree murder? Okay, first degree murder requires an intent to cause the death of someone, not just intent to do the actions that lead to the death of someone. And there's a distinct difference between that. First degree murder is pointing a gun at someone's head, going, I want this person to die, and pulling the trigger. Something like that, okay? That is the mindset required for first degree murder. Murder in the third degree is a little bit different. Let's read this. Section A is the section that's relevant here. Whoever, without intent to affect the death of any person, causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind, without regard for human life, is guilty of murder in the third degree and may be sentenced to imprisonment for not more than 25 years. So the idea here is that by placing the knee on the neck of George Floyd, that he was not trying to cause his death specifically, but rather that he was acting with such disregard for the damage that that knee on the back of the neck could do, and it ended up causing the death of George Floyd. And frankly, I think that is a more appropriate and wiser charge based on the evidence that we have at this time. They're not going to win a first-degree murder charge unless they were to find out something along the lines of some sort of pre-existing relationship between Chauvin and Floyd, and an intent by Chauvin to cause some sort of damage to Floyd, or to cause his death. Not even just to cause damage, but to do an act that he knew would kill him for the purpose of killing him. And at this time, outside of like a phone being searched and some text messages and pictures, something like that, or some radio chatter that we missed, or something else, they just don't have the evidence to make that charge happen. So prosecuting that charge could end up in an acquittal. You don't want to overcharge, especially when you are charging cops, because juries are favorable to cops. They just are. They just are. I don't know how else to explain it than that. Juries are extremely deferential to the duties and dangers of police work. And that becomes a problem when you undertake a prosecution that is overzealous. So I think this is the wise charge here. It covers the elements that we know, and we'll see from the complaint what sort of evidence that they have, or we'll get an idea of the narrative, I guess, that is driving this charge. All right, the other charge is manslaughter in the second degree. This would be sort of a fallback charge on this. So a person who causes the death of another by any of the following means is guilty of manslaughter in the second degree and may be sentenced to imprisonment for not more than 10 years or to a payment of fine of not more than $20,000 or both. And section 1 is the relevant one here. By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. Okay, so the first one is an intentional act. That's the murder in the third degree, is an intentional act placing someone in danger. Okay, so the idea is that by putting the knee on the back of the neck, he is creating knowingly and intentionally an unreasonable risk of someone dying by having a reckless disregard for their overall safety. Manslaughter in the second degree is different. It is to negligently place or unintentionally violate your duty is a different way to word it, right? So unintentionally violate your duty to the other person. So in this case, it would be placing a knee on the back of the neck, not having a reckless disregard for the person, but just creating an unreasonably high amount of risk. I actually think the murder charge is a stronger charge in this case based on the facts, but this is a catch-all in case they were to find some evidence that somehow he had no idea that putting his knee onto someone's carotid artery or the back of their neck, or just applying pressure downward to someone's upper torso when they're in a state of elevated breathing or something, could cause that damage. That's going to be, in a weird way, that's almost harder because he's a trained police officer and a veteran police officer who has been on the police force for well over 10 years. All right, so these are the charges. Now, I have the complaint as well, and that is what I would like to go through here. I have redacted his address, not out of respect for him at all, but because YouTube doesn't really like addresses. This is a publicly available document. If you want to see the full version, please, go find it. It's out on news stations and everything. You can find it. But just due to YouTube's policies, I try and avoid showing addresses, okay? His name is Derek Michael Chauvin, date of birth 3/19/1976. This is a warrant complaint, so this is a warrant for the arrest of Derek Michael Chauvin. You can get a warrant or this is as a result of a warrant, I should say. You can have a warrant or a summons, and I'm actually going to cover that when I talk about George Floyd's botched arrest in another video, the difference between a warrant and a summons, and why this whole scenario could have easily been avoided under the Minnesota rules of criminal procedure. There was no reason to do an arrest of George Floyd for this criminal act, alleged criminal act that he committed. And all of this could have been avoided very, very simply. It's amazing. But that being said, let's go through this. So count one, we have murder in the third degree. And here is the charge description. So this is a loose application of the facts to the law specifically. That on or about May 25th, 2020, in Hennepin County, Minnesota, Derek Michael Chauvin caused the death of George Floyd by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life. And again, the way he's talking to him, the way he's acting, if they can link the knee to the death of George Floyd, this is going to be a very strong charge against him. So the charge description for manslaughter is that on or about May 25th, 2020, in Hennepin County, Minnesota, Derek Michael Chauvin caused the death of George Floyd by his culpable negligence, creating an unreasonable risk and taking a chance of causing harm or great bodily injury or great bodily harm to George Floyd. Causing death or great bodily harm. Goodness, learn to read, Nick. That is the backup charge, as I said. If they are not able to get the murder charge because they have trouble showing the intentionally dangerous acts and the depraved mind, they can go ahead and reduce it and say, well, he wasn't acting with a depraved mind with disregard for human life. He was just acting carelessly or negligently, and he had a duty to not do so. All right. So here is the statement of probable cause. This is the narrative that we have on the arrest of Derek Chauvin here. And this has some stuff that we have not seen, or at least I have not seen from the released footage. That is, it's some of the critical moments between when they had brought George Floyd over to the squad car and how he got to the other side of the car. And I think it's pretty interesting. And it may change some people's minds in some ways, but it shouldn't. I don't know how else to say it. It shouldn't. And I'll talk about the problems that I see in this thing as we go. On May 25th, 2020, someone called 911 and reported that a man bought merchandise from Cup Foods at 3759 Chicago Avenue in Minneapolis, Hennepin County, Minnesota, with a counterfeit $20 bill. I believe we know that someone is a guy named Mahmoud who worked there, because he was interviewed by a news station. I'm not sure why they don't have his name there. Maybe the call came from someone else, or they just didn't want that guy's name in the charging document because it would be publicly seen and maybe put him at risk. I'm not sure, but they have an interview with the guy who allegedly called the police available on a news station, and he talks about why he called the police over a counterfeit 20. At 8:08 p.m., Minneapolis Police Department officers Thomas Lane and J.A. Kung arrived with their body-worn cameras activated and running. The officers learned from store personnel that the man who passed the counterfeit 20 was parked in a car around the corner from the store on 38th Street. BWC video obtained by the Minnesota Bureau of Criminal Apprehension shows that the officers approached the car, Lane on the driver's side and Kung on the passenger side. 3 people were in the car. George Floyd was in the driver's seat, a known adult male was in the passenger seat, and a known adult female was sitting in the back seat. As Officer Lane began speaking with Mr. Floyd, he pulled his gun out and pointed it at Mr. Floyd's open window and directed Mr. Floyd to show his hands. When Mr. Floyd put his hands on the steering wheel, Lane put his gun back in its holster. This is, at the start, I have an issue here. Why is a gun being drawn? Look, I know you haven't seen his hands yet, but why is a gun being drawn? Why? This is a forgery, right? We have no evidence of physical violence being threatened in this document. Maybe there is some on the body camera, or maybe the store owner mentioned that he had a gun. I don't know if that is there or anything like that, but it's not here in the probable cause determination. So I'm going by this. I have a problem with him pulling a gun at this stage. Why are we doing that? Why is this already escalated? This is a non-violent crime over a $20 counterfeit bill. And they're just taking the store owner's word for it that George Floyd is the guy and that he's parked in the car. I mean, they don't actually know at this point if this is something that's even real, right? Anyway, we got to keep going. While Officer Kung was speaking with the front seat passenger, Officer Lane ordered Mr. Floyd out of the car, put his hands on Mr. Floyd, and pulled him out of the car. Officer Lane handcuffed Mr. Floyd. Mr. Floyd actively resisted being handcuffed. So he didn't want his hands to be put behind him. And if you have seen the video of that, he puts one hand out on the door and the other hand is over here. The act of resistance lasts a short amount of time, but that is the resisting arrest, I'm guessing, that they talked about initially. Once handcuffed, Mr. Floyd became compliant and walked with Officer Lane to the sidewalk and sat on the ground at Officer Lane's direction. In a conversation that lasted just under 2 minutes, Officer Lane asked Mr. Floyd for his name and identification. Officer Lane asked Mr. Floyd if he was on anything and explained that he was arresting Mr. Lloyd. Look at the typos, guys. Come on. I mean, you did have 3 days to type this up for passing counterfeit currency. Officers Kung and Lane stood Mr. Floyd up and attempted to walk Mr. Floyd to their squad car, MPD 320. At 8:14 p.m., Mr. Floyd stiffened up, fell to the ground, and told the officers he was claustrophobic. And we've seen this from the video. I didn't know why he fell in the first place, but apparently he stiffened up and kind of drops to the ground, and he's saying he's claustrophobic. Now, do cops automatically have to believe someone who says they're claustrophobic? No. Do they have to not put someone in a squad car because they're claustrophobic? No. They can do that. They can still do it. And but this doesn't qualify in my mind as active resistance to the arrest, and they're not calling it that in this document. So MPD officers Derek Chauvin, the defendant, and Toa, I hope I'm pronouncing that right, then arrived in a separate squad car. The officers made several attempts to get Mr. Floyd in the back seat of Squad 320 from the driver's side. Mr. Floyd did not voluntarily get in the car and struggled with the officers by intentionally falling down, saying he was not going in the car and refusing to stand still. Mr. Floyd is over 6 feet tall and weighs more than 200 pounds. While standing outside the car, Mr. Floyd began saying and repeating that he could not breathe. The defendant went to the passenger side and tried to get Mr. Floyd into the car from that side, and Lane and Kung assisted. Okay, so now we know that they have gone around the vehicle to try and get him in the side door. The defendant pulled Mr. Floyd out of the passenger side of the squad car at 8:19:38 p.m. This is a weird inconsistency. They attempted to get him, they tried to get him in the car, but then they pulled him out of the passenger side of the squad car a minute later. I don't know how to describe this because we haven't seen it yet. Hopefully the body cam footage will be released and we'll see it. At the time of this video, I haven't seen it yet. But this is a weird thing. If he's in the squad car, why are you pulling him out of the squad car? And Mr. Floyd went to the ground face down and still handcuffed. Kung held Mr. Floyd's back and held his legs. The defendant placed his left knee in the area of Mr. Floyd's head and neck. Mr. Floyd said, "I can't breathe," multiple times and repeatedly said, "Mama," and "please" as well. The defendant and the two other officers stayed in their positions. Now, this is a weird scenario already because he's voluntarily falling as best we can tell. That's the narrative from this, is that he is stiffening up and going to the ground. If he's falling to the ground, there's not really a need to restrain him in this way by the knee on the back of the neck. I know that anybody could get up and do something. Mind you, he's handcuffed and he has two other officers on him. He's laying prone on the ground. I'm not sure why a knee needs to be placed on his neck. And this, of course, is going to be the big impetus for these charges. Why are you feeling the need to restrain him in this way? Putting him into the ground like this is not going to get him compliant into the car. You're not gaining compliance. He's not trying to flee. He's trying not to get in a vehicle. Well, putting him down on the ground and restraining him by the neck is accomplishing his goal of not getting into the vehicle. They're not gaining compliance to put him into the vehicle. So we'll keep going. The officer says, "You are talking fine" to Mr. Floyd as he continued to move back and forth. Lane asked, "Should we roll him on his side?" And the defendant said, "No, staying put where we got him." In hindsight, you should have rolled him on his side or onto his back. Absolutely. Officer Lane said, "I am worried about excited delirium or whatever." The defendant said, "That's why we have him on his stomach." None of the three officers moved from their positions. BWC video shows Mr. Floyd continue to move and breathe. At 8:24:24, Mr. Floyd stopped moving. At 8:25:31, the video appears to show Mr. Floyd ceasing to breathe or speak. Lane said, "Want to roll him on his side?" Kung checked Mr. Floyd's right wrist for a pulse and said, "I couldn't find one." None of the officers moved from their positions. So at this point, he has appeared to stop breathing. They cannot find a pulse, but they maintain their positions on him. And again, this is going to push more towards that third-degree murder charge than the manslaughter charge. By maintaining the same pressure that may have rendered a man unconscious and unresponsive, you're causing further damage rather than making attempts to resuscitate, or rather than making an attempt to stabilize or secure the health of the victim. This is the depraved mind aspect of it that they're looking for with a third-degree murder charge. All right. At 8:27:24, so we're talking almost 2 full minutes have passed since he has become unresponsive. The defendant removed his knee from Mr. Floyd's neck. An ambulance and emergency medical personnel arrived. The officers placed Mr. Floyd on a gurney, and the ambulance left the scene. Mr. Floyd was pronounced dead at Hennepin County Medical Center. Now, this is written a little bit out of order from the video. We know that his knee is still on the neck when the ambulance and medical personnel arrive and check the pulse while the knee is still on the neck. And then the knee is removed. So I'm not sure why they wrote it this way, but that's what they've written down. Hennepin County Medical, and no, there's not really going to be some sort of defense based on the inaccuracy of the complaint for that type of detail, because it's not, one, it's not specific enough to the crime, and two, it has nothing to do with whether or not this guy died. He did. Hennepin County Medical Examiner conducted Mr. Floyd's autopsy on May 26, 2020. The full report of the ME is pending, but the ME has made the following preliminary findings. The autopsy revealed no physical findings that support a diagnosis of traumatic asphyxia or strangulation. So he didn't die from a crushed windpipe. And I think that's kind of clear from the video that he wasn't dying from physically having his windpipe compressed. He is still able to get air out through the windpipe. And a compressed or obstructed windpipe, when it's fully obstructed and you cannot breathe, you cannot talk. And the officers did mention you're talking just fine, you can breathe. That doesn't actually mean that you're able to draw in breath into your lungs in a significant way to keep you conscious or living. It just means that air can pass through the windpipe. Mr. Floyd had underlying health conditions, including coronary artery disease and hypertensive heart disease. The combined effects of Mr. Floyd being restrained by the police, his underlying health conditions, and any potential intoxicants in his system likely contributed to his death. So we have no idea if there are intoxicants until the full medical examiner's report comes out. The police mentioned that he seemed intoxicated in some way. Shockingly, having an intoxicant in your system is not grounds for the arrest, and they did not arrest him for an intoxicant in his system. They did state that they were arresting him for the counterfeit $20 bill. So I just want to point that out, that that's in there. We'll see what the ME says. But if you create a situation that leads to the death by being negligent or by being wantonly or recklessly disregarding of the human safety, those underlying factors are just contributory to the death, and the cause is still the cause of the actual act that led to the death. Does that make sense? I hope so. Placing a knee on someone's neck is the primary factor if it triggers these secondary effects. That doesn't make it not a murder, okay? And the other problem, we may see further charges on this as the facts become more and more available. They now have probable cause to affect the arrest. They can amend this complaint and add other charges. I would suspect if they don't believe they can maintain the third-degree murder charge, they may amend the pleadings and the complaint and add in a felony murder charge where they find some other felony, like maybe the manslaughter charge, or not the manslaughter charge, but maybe an excessive force violation or something like that, or some sort of battery charge, and then add in a felony murder charge as well. I don't know if they'll do that or not. I think they still have enough based on this complaint and the video to get that third-degree murder charge anyway without having to utilize other elements of the law like that. But I'm just saying what they may end up doing if they become if the medical examiner's report comes back and decreases their confidence in the third-degree murder charge, we may see some amendments to the complaint going forward. The defendant had his knee on Mr. Floyd's neck for 8 minutes and 46 seconds in total. 2 minutes and 53 seconds of this was after Mr. Floyd was non-responsive. Police are trained that this type of restraint with a subject is in a prone position is inherently dangerous. Defendant is in custody. And I want to stress that. It's been talked about that this is a police-trained technique, and it kind of is, but that training also entails that this technique is to be applied for a short amount of time to gain compliance. Think 30 seconds, something like that. Because typically 30 seconds of compression on one of the arteries in the neck would actually lead to potential loss of consciousness. And if not, it would lead to the compliance of the person. Here we have no evidence from the videos or from the charging document or anything so far to figure out what compliance they were actually trying to achieve. Like, what was the end goal of holding him into the ground? Was it holding him till the medical emergency medical people got there. We don't know. Maybe they were planning to sedate him and then transport him by ambulance. I'm not entirely sure on that. What I do know is they did not attempt to get compliance to get him back into the vehicle. And it seems like if you're attempting to effect an arrest, that would be the compliance you're looking for. But I'm, here I am. I'm just a humble defense attorney. And what I see here is something different. I will do a follow-up video as more evidence comes out on how Derek Chauvin's defense attorneys may try to defend this case. And we'll see. Right now, they've got a strong charging document. They have tons of video evidence. They have plenty of discussion from Chauvin to create the idea of a depraved mind, creating an unreasonably unhealthy situation for Mr. Floyd that led to his death. I mean, they have the elements of the charge. Of course, you're going to have a jury and you're going to have attorneys on both sides of this, and those attorneys will pretty vehemently fight over this, and someone will have to make a determination. The jury will have to make a determination of guilt, so there's no guarantees in anything. Right now, they have a strong case. Did they need to wait for this charging document to arrest him? No, they could have arrested him on the day. They could have arrested him at the time, but they didn't. And they tend not to do that with police, which is great for you and I, because if you or I did this, the same actions, we would be arrested immediately and we would have a very high bail number. But he is now under arrest, and we will see what happens from here. But this is the document. This is all of the facts that they have released at this time in relation to it. There are more pages to this. They're not super interesting. Here are the charges. Again, Section 1 of the manslaughter and Section A of the third-degree murder charges. So they're both felonies, 25 years on murder, 10 years on manslaughter. Hope this helps you guys understand what's in the charging document, what they're actually using for to affect the arrest as a factual narrative at this time. This is not all of the facts. This is the bare minimum level of facts required to get probable cause to affect the arrest. There is a possibility that any or all of this evidence could be included or excluded at trial. That's not the point of a probable cause hearing. And so, evidentiary concerns aside, do they have enough information to affect the arrest for these two charges? Yes, absolutely. And I'm glad he is arrested and in custody at this point. But what happens next? More evidence will be brought in via discovery, police interviews with him, interviews with the store owner, with eyewitnesses that were there, review of all of the videos. All of that is going to be a part of this, and this will take a little while. COVID, of course, not helping things as well. But hope you guys found this video helpful and useful to everything. Please hit like and subscribe if you like this sort of stuff. We'll be following this case as it develops because it's in my state and it's kind of in my field. So here we go. Hope you guys have a great day. If you're in Minneapolis, please stay safe and don't participate in looting and riots. It's not helping, and it is definitely a dangerous endeavor. Stay safe and have a good day. Peace. Peace.